Hi, everyone. This is Arkady Frekhtman, and welcome to Raw Law. I'm a New York City personal injury trial attorney, and this is the show where we read your comments and we answer your questions. So, welcome, everybody, and let's get into it. I see we have a few questions here already, so let's get right into it. Let's see. Let me go up to the first question, and we'll start. We'll start right away. The first question I see is from Frost Midnight. And the question is, do attorneys usually give clients verdict predictions? Let's say 500,000 on their own case. And what if a client isn't phased and thinks they could get the whole million if they keep fighting? So I guess your question is whether the lawyer will give the client a prediction. So, I mean, that's a good question. It depends on the lawyer. I mean, some lawyers can give clients an idea or like a range of what they think a case could be worth. Like I do that sometimes. But what I've seen a lot of lawyers do, especially, the more traditional method, is that they tend to err on the low side. So they're going to tell you your case is worth a lower amount. And then if they get close to that number or they beat that number, then they look like a hero, right? So, but it's kind of like a tactic that they do in order to be a hero, in order to get you to settle. So, they're not going to tell you what the case could potentially really be worth. It just depends. But like that's what I've seen people, and a lot of times they'll just say, look, if you settle, it'll be a number that you're happy with, right? Because a settlement is like a contract. So it's like both sides shake hands, you agree on the amount, and that's the amount you get. But if you go to verdict, then it's up to the jury. So, of course, we're going to do the best job. We're going to try to present the evidence in the best possible light. But ultimately, it's up to that jury. So the jury could give you what you ask for. They could give you more. They could give you less. We don't know what a jury is going to do. So that's usually how most lawyers handle it. Because, they don't want to be in trouble. They don't want to say your case is worth 10 million and then they go to court and they get like 10,000, then they look like a clown, right? So that's basically the issue. And then Frost also asks, did the opposite side ask for any of your clients' social media websites, usernames, and passwords during the litigation process? I mean, they do sometimes ask for social media, not usernames or passwords, but they sometimes ask for like social media information. And there's different ways to handle that. We usually what we do is, we tell our clients, keep your social media like private or don't post anything. So if we do have to disclose it, it's up to the judge. But if we do have to disclose it, there won't be anything there that's, bad, basically. Or the other thing you can do is just not have social media while you have your case and then, start it up again after. That's probably the best thing. And then he also says, do you have or had cases where clients demanded policy limits, let's say in a trucking case, but it ended up settling for less because the insurance company lowballed and do not budge when negotiating? I mean, not that I could think of. I mean, usually, yeah. I mean, we've had cases where we've demanded, let's say, policy limits, and they've settled for either policy limits or close to the policy limits. We don't really play that whole insurance game. So if the insurance company comes in really low and says, "Look, for example, if it's a million policy, and they say we're only going to pay like 150,000, but we have a good case, and we know, hey, if we go to court to a jury, this case is worth a million. This case could be worth 3 million." We don't play that whole game. We don't get scared of the insurance company and say, "Oh, we're gonna, only take 150,000. That's all they're going to give us." We just kind of set our own value and say, "Look, this case is worth 3 million, but because you only have a million, pay us the million. You have until, let's say, November 10th, 2025 at 5 p.m. And then November 10th, 2025 at 5:01 p.m., it's not going to be a million anymore. It's going to be three. So then what are you going to do if I go to court and I get the three from a jury? You only have one. Now, are we going to take the trucking company? Or are you going to be the policy going to be open? And then whatever number we get, whether it's 3 or 5 or 7, you're going to have to pay the whole thing. And they don't like that, right? Because they like to manage or limit their risk. They don't like this boom, blowing up their risk. So then they get scared and they usually pay either the full million or they might pay like really close, like 850, 950. So we've had a bunch of those. And let me do this question from Darren Proctor. He says, it's almost 90 days. I did not receive the IME report. After the 90 days, can my attorney put in a motion to compel? I have multiple injuries. Yeah. Oh, yeah. I think we talked about this before. Yeah. I mean, your attorney could put in a motion, but like the IME report, basically, you saw the doctor. So the doctor probably has the notes, and probably just because they see like, 50 people a day and they have so many, they just didn't get to write it yet. But there's no like urgency in getting this IME report. I think I told you I had a case where they were holding the IME report from 2023 and I got it just like a few months ago. It doesn't really matter. I mean, I don't know why you need this IME report, why you think it's going to change something. Like, it's just basically the standard report where they just say you're not hurt, or if you are hurt, it's not from the crash. You're going to get it before trial, your attorney. If your attorney feels like they need it, they could make a motion, but nothing really changes whether you get it now or you get it later. I mean, I know they do have deadlines, but I've never heard of, an IME report resolving a case. Or it's basically just the doctor saw you, the doctor has the notes, the report like exists in some form, right? A draft. They just have to finalize it. They're probably just busy because they see 50 people a day, and they just don't have time to write it. But it's the same thing. It's like basically a template, and they just plug in your name and basically say that you're not hurt. So it's not going to really, even if you get it, it's not going to really change anything in the case. It's just one of the steps in the process. Okay, so we did that, and then let me see. Here's another question from Frost Midnight. Do insurance companies ever budge and pay what a claim is really worth, or they don't care since they're big corporations willing to go to trial, no matter the attorney or his high settlement and verdicts? No, yeah, they do. I think I answered that in the last answer. It depends on how you negotiate with them, right? So if the insurance company is, for example, giving you like 150, right, in that example, and you're trying to get $1 million, and they say, look, you have to demand something less than 150, and you say, okay, I'll demand like 145. Well, now they're maybe going to offer you like 70, and they see that what you've now done is you've given them a gift of like 850,000, because you can't then say, oh, wait a minute, I'm going to demand 250, 350, 450. You've already demanded 145, right? So that's what they want you to do. They want you to basically, what they want to do is bully you. They want to say, hey, your case isn't worth $1 million. Demand, it doesn't have to be 150. It could be 300, 500, whatever. Demand less than X. And then, they want to drag you. They want to see how far down they can drag you and get you to settle for the smallest possible number. And if you play that game, right, and when you go to court, even the judge says, what's your demand, counselor? And hey, you got to make a demand less than X. And if you play that game and you make a demand less than X, that's it. Everything above X is gone. You've just given them a gift, right? So you don't want to do that. Like, I just don't like that whole strategy. It's what they want you to do, or the insurance companies. So just don't play their game. Just basically have your case evaluated by your attorney, have your case evaluated by focus groups. Now they have like big data you could do, where you could show the case to thousands of people and have them tell you what the case is really worth. And then those numbers are accurate. Basically people are going to court doing big data, being told, hey, your case is worth 19.1 million, and then take a verdict and it's like 19.2 million. It's like, uncanny. It's like almost to the penny. It's like the money ball. They really know now. So there's a lot of things you can do, but my point is, you should tell them what to pay. Like, I'm not saying just every case go out and say, hey, it's worth 10 million, right? That's not what I'm saying. But if you do have a good case, like either a brain injury, a fusion, open reduction, internal fixation, any kind of life-changing forever injury, what you should do is, evaluate the case, look at all the categories of damages that are available. Like, for example, of course, non-economic damages, like past pain and suffering, future pain and suffering, how many future years. A lot of people, they're young, they have like 40, 50 future years. So even if 1 year is $1 million, well, then 40 years is like 40 million. It's crazy, right? It's big amounts. Now, lost earnings, profit, your profits, your lost earnings, your lost salary, future medical costs. But these are all separate categories, but you add them all up, right? And then when you add them all up, it could be a really big amount. Show that to them. Like, what I do is I write them a letter. It's like a detailed 15 or 20-page letter. All the categories are there, all the medicals are there, the chronologies. I have evidence to back everything up, and I say, look, pay me X, pay me, for example, $1 million. That's all you have. You have 30 days. If you need more time to evaluate it, to get supervisor's approval, just let me know. I'll give you more time. I'm cooperating with them. But the bottom line, don't bully me. Don't tell me to take 100,000. Why? Look, I have all the evidence. If I go to court, I'm going to get more than $1 million. And my number is maybe 7 million in my letter. So pay me the $1 million. If you do, it's settled. If you don't, then fine. But then, don't expect me to demand $1 million or go to trial and ask for the same $1 million at the end of the deadline. When the letter expires, it's going to be like, 3 million. And then maybe it'll be 5. And then by the time I go to trial, it might be 7. I go the other way, basically go up the other way. Then they get scared. They don't like that. Like I was explaining. So yeah, you could totally. And insurance companies do budge. They do pay. Like I had a case with Allstate, for example, where I had a lady who got hit by a car, pedestrian, brain injury. And the adjuster was saying ridiculous things. Like the lady had a really bad brain injury with like subdural hematomas and blood on the brain. And, she put the stove on. She didn't remember to turn it off. And she had little kids in the house. It was like really dangerous. So I said, look at all this evidence, pay me the $1 million. And this adjuster was saying ridiculous things like, how do we know that it won't just go away? And I was like, come on, this is ridiculous. It doesn't just, brain injury like that doesn't just go away spontaneously. So I just said, look, I just stuck to my guns. It took a few months, and then they fired their in-house lawyer. They hired some big firm lawyer. I forgot who, but some big firm, because they're scared, right? So they're firing one lawyer, hiring another lawyer. And then ultimately they're like, yeah, I see, of course, they just paid the $1 million. So fine, but that's just an example. But yeah, you could definitely get them to go up. There's not really an issue with that, as long as you have a real trial lawyer and they know how to prepare the case. Okay, and then Healthy Lifestyle asks, rear-ended by an Amazon van, underwent an ACDF C6-7 surgery 11 months after the accident, received 2 epidurals, and my medical expenses have exceeded $100,000. Considering this is in Queens, New York, what kind of compensation might I expect? Right. So, it's hard for me to say exactly, but if you got rear-ended, if it's Amazon, definitely find out how much insurance. If it's one of those delivery service partners, there's a lot of lawyers now that know how to, basically sue Amazon as well. Not just the delivery service partner, but Amazon, because Amazon controls them. And then you can get more coverage. But if you have a lot of coverage, let's say you have like 5 million, 10 million, whatever it is, it could be big, because ACDF C6, C7, that's already, I would say, worth a few million. I don't know how old you are. I don't know how many future years of pain and suffering you have, past years. But yeah, it's a good case. You also can put future medicals on it, because you'll need adjacent segment disease. If you have a C6, C7, well, then later on, you're going to have the adjacent levels, the ones next to it, like C5. That's medically known that you will need surgery. Maybe not now, maybe in 15 or 20 years, but it's a medical probability to a reasonable degree of medical certainty. You will need adjacent surgery. So, at the C8 and the C5, the adjacent levels. So that could be expensive. Just those surgeries could be like 200,000-300,000. But then you figure also physical therapy, prescriptions, everything adds up. So just the medical bills could be, 2 million, 3 million. So you have that, you have pain and suffering. I don't know if you have lost wages. You just go through all the categories, whatever categories are applicable. Then there's, of course, loss of enjoyment of life. So it depends on who's handling the case. If you have a good trial lawyer and they're like spending time with you, understanding you, getting your photo albums, your pictures from like your iPhone or your photo album, exchanging that, saying, look, this is how it changed my life, right? My family's life. And this is who I was before. This is who I am now. Well, now it's going to be worth a lot of money, right? Because a jury could identify with that. Like I was working on some jury selection today, because I have a trial coming up also in early November. And like one of the questions that some lawyers ask, actually 2 different lawyers, they're both really good. They ask like, what's the singular most important thing in your life, right? And what are jurors going to say? They're going to say like family. Some people are going to say like freedom, right? The ability to be happy, ability to do what I want to do, things like that. So like if you don't have that, right? If your family now, instead of you being a member of your family, but now maybe you feel like a burden to your family because your family has to take care of you, or you don't have the freedom to do things that you want to do. because you're so injured, right? That's worth a lot of money. And then you pick the right jury who agrees, who has those values, and then you show them in your case those same values, and then they're going to allow for millions and millions of dollars for non-economic damages like pain and suffering, the loss of health. One attorney said something like recognizing the loss of health with monetary compensation. And I thought that was really a smart way of putting it, right? You're recognizing the loss of health that's permanent with monetary compensation. And are you able to do that? And you kind of see what the jurors tell you in the jury selection. And then the ones that can, of course, you keep, and the ones that cannot, you get rid of. So that's really, so, it's hard for me to say, because remember, this is like more of an art. This isn't like a science where I could tell you, you're going to get $3,124,000. I mean, I could say that, but it's all baloney. It's an art, right? So it depends on the lawyer, it depends on how they're doing the jury selection, how they're doing the negotiating, right? If they're doing the negotiating the way I just mentioned with the settlement opportunity letter, or if they're doing it the old school way where they're trying to, if the insurance company tells them, hey, you better demand less than $1 million, and then I'll have real money for you. Well, who knows, right? Maybe the lawyer has a car payment to make, or maybe they have a problem with their mortgage, or they're getting a divorce. So who knows? There's a million problems. Maybe the lawyer's like, well, wait a minute. They just told me if I demand less than 700,000, they're going to give me real money. Okay, I'll demand less than 700. Oh, I just got you 600. It's such a great number. But meanwhile, your case could be worth 6 million, but they just want to get the money for themselves because they have some kind of a personal financial issue, right? There's a million possibilities. That's why I can't really tell you like what your case will be worth based on a comment. But the best thing to do, like I've said before, is just to text me 347-566-9595, and I'm happy to do a consultation. Then we could talk. We will know more about like what your case is truly about. Like we'll know your age, who's handling the case. I could do searches on the attorney and show you like their verdicts. Some attorneys, they have good verdicts, and I'll show you that. I'll send you the PDF. Some don't have any. Some have bad verdicts. Some say they have $5 million, but when you go there, they have $5,000 or zero. So it's just it's like anything's possible basically. But yeah, generally, like I was saying, that's a good case because with the Fusion, and Amazon usually has a lot of money, obviously. So you should be in good shape. And Queens is fine. I mean, Queens is a little bit like a melting pot where you have different communities. You have like a Spanish community, Indian community, Chinese community, but you just have to pick the right juror, speak to them and pick the right jurors. It's not about like their ethnic background. It's more about like who they are as people, and pick the right jurors that are willing to, be fair on your case. That's what it's all about. And then let me see. We have a question here from Bubakar. 2 months after deposition, but no sign for settlement. Well, yeah, I mean, like a settlement could be at any time. It doesn't have to come after the I mean, usually it comes after the deposition, right? Because if they haven't even had a deposition, they don't know anything about the case. So there's their chance to ask you questions like, what happened? What are the facts? Why are we at fault? What's your injury? What treatment have you gotten? Now they have information, so now they could settle. But it doesn't mean that they have to. They might think that the case is no good and they don't want to settle at all, right? So a settlement could come at any time, and it could also never come. You might have to go to trial. So there's no guarantee, that you're going to get a settlement just because you had a deposition. And Machiavellis says, hi, Arkady, the defense is changing law firms after the depositions, but we are doing IMEs. Is that good or bad for my case? Discovery is almost completed. I mean, it could be, it's not really good or bad. It depends on why they're changing. Sometimes they change because another firm gives them a better rate. Like a firm might be charged $500 an hour, and the insurance company doesn't want to pay $500. They say, hey, wait, this is a new firm. They're just as good. They have excellent lawyers. Look, one of these lawyers just took a defense verdict last week, and they'll do it for $275 an hour. It could be anything, right? So it might be that. It might be sometimes they change, like I said earlier in this broadcast, when you send them a letter and you say, look, if you don't pay me the $1 million, I'm going to go to court. I'm going to get 3. And then they get scared and they're like, wait a minute, we just have in-house counsel. They're just like, not doing anything. Let's get a big firm on this case. Maybe they could help us. And they change lawyers because of that, because they see that the case has exposure. So there could be many reasons why they change lawyers. So it doesn't necessarily have to be good or bad, but I mean, I guess it's good in the sense that the new lawyer is like not really familiar with the case. They have to get up to speed, but it also depends on who was the old lawyer and who's the new lawyer. Sometimes they change from like an in-house counsel who's kind of weak or just overwhelmed to like a bigger firm that has more lawyers, more resources. So that's actually going to be harder because then you have to go up against a harder opponent. But it depends, like, who they're changing to. You know what I mean? So it's just, we couldn't really say good or bad just from that. Okay, and then Zafraz says, "Hey, Mr. Arkady, how often does a case settle at a pretrial conference?" Yeah, I mean, it does. It settles. It settles like I was saying. It settle at any point. It could settle at a pretrial conference. It could settle before. It could settle after. It could settle during trial. I don't know like how often it settles specifically at a pretrial conference. I mean, you'd have to get like every case in the nation and do some kind of statistical analysis. I don't know if anyone's doing that, but yeah, I mean, it's kind of a very broad question. It just depends on the case. Like if the case is good and you push the right levers and you kind of make them settle, then they'll settle. If the case is bad or the attorney is just kind of like sleeping on it and you're not pushing any levers and you're not giving them any reason to settle, well, then they're not going to settle. Um, so basically, like the pretrial conference is just like another stage in the case. The point is to get a trial date. The point is to make sure that both sides talk about, like, I mean, of course, settlement, but also if they're not going to settle, what's going to happen, what's the next step, who's going to be the trial attorney, who are their witnesses, how many days the trial is, kind of like a preparation for the trial. Then you get a trial date. So yeah, that case could definitely settle. I mean, that's a good time to settle because it's kind of like, you're getting closer to trial. And Machiavellis says truck accident case. Okay. Yeah. So if they're changing lawyers in a truck accident case, I mean, it could be a good thing. Could be that they're afraid that they see exposure. You'd have to, ask your lawyer, whoever's handling it. They probably would know better. And then Dwayne says, what if you make money off of social media, shutting it down during the settlement? Is that a claim for income? Well, I mean, you don't have to shut it down. The point is, like, you could have social media. I mean, if you're like making money off of it and you're doing something like, videos, as long as you don't testify in a deposition that you cannot do a certain thing, right? Like, for example, if you testified in a deposition, you cannot do X, like you cannot, I don't know, run, and then you're on social media running. Well, that's not good, right? Because now you're lying. They could have you and they'll put the social media up and be like, look, he's just said he can't run, he's running. So, but if you're doing something like, like this, like just sitting there talking or making money in some other way, that's fine. Or showing videos of past, things that you did that before you got hurt, that's fine. It just depends on, you just have to basically like, speak to your lawyer and formulate a strategy for that so they don't lower your case value. But yeah, I mean, I suppose I see, in order to make money on a claim for income loss, you would have to show not that you're not doing the social media because they're following you or whatever, because you can't do that. But what you could do is you could say, I can't do X, right? Like, for example, if your social media shows you doing something like, I don't know, riding bikes and, whatever, jumping bikes, and you can't do that anymore because you're hurt, well, then you could say, yeah, and I made money with social media. Then you could make money as a lost earnings claim, of course. And then Akar says, hi, Arkady. I asked the question about a grade 3 ankle sprain with a 5% permanent disability, 16 weeks of physical therapy, trip and fall, apartment complex, aggravation of migraines, 6 ER visits, 3 stem cell injections, 110 in medicals, wondering what the case might be worth. Yeah, I mean, like, again, like, it's really hard for me to say, like, just from a comment, because I don't know, like, what venue you're in, what stage the case is in, how old you are, all these things come into play. So I'd have to really review the file. But generally, I mean, sure, if you have all this physical therapy, you have a good, like, trip and fall case, there's an unsafe condition, and it should be worth a significant amount. It sounds like to me like it should be worth maybe a few $100,000. Grade 3 ankle sprain, and you have disability, I just don't know like where where you are. A lot of it depends on venue. Like for example, a fusion in the Bronx could be worth like 3 million, but the same fusion surgery in like I don't know somewhere West Virginia could only be like 300,000, right? So it's hard for me to say exactly, but usually it sounds like it could have substantial value. And Cali Cool says, why Uber doesn't want to pay passengers that are hurt in crashes? Uber. Yeah, Uber is just kind of like really not so good with these cases. What they're basically trying to say is that when you sign the agreement, that you're kind of giving up your right to sue, and that you agree to go to these arbitrations, and then the arbitrations are like these arbitrators that are like very favorable to Uber, so they give very low amounts. So the whole thing with Uber is like, yeah, hopefully that changes. And they're also trying to pass all these bills everywhere. Like they tried to pass one in, I think, Nevada, near Las Vegas. I think it failed, where they were trying to like say that attorney's fees should be lower because that's why people are suing, because attorney's fees are high, or some kind of I forget, like 15% they were trying to lower it, but that got shut down. But they're basically trying to, you know, I guess they're a big company. They make a lot of money, right? Where they're like 40 billion or more. So they're trying to like, use their strength to limit these cases. But I don't think that's really the right approach. It's not about the cases, right? It's not about people like suing Uber, or people aren't just going to go and sue Uber. It's about like just being safe, like make sure you have safety measures, your drivers are driving safely. If an accident does happen, then you have to take care of the person. You have to compensate them. It's just not fair. But yeah, I mean, yeah, I don't really, now there's a whole thing I saw today with Uber with the sexual assault cases. I think there's a trial and they're looking into it with Congress too. So Uber is like a lot of problems with Uber. But yeah, unfortunately, depending on where you are, I mean, Uber does have big policy, so you could sue them, under that. But the problem, like in New York and places like in New York City, they consider it, I think, the TLC. So if you're in New York City, it's kind of like the taxi, which is only 100,000. So even if you have like a million policy, you can't get it. So that's a problem. Hopefully they change that, because like if you're in, let's say, Long Island or Westchester, then you could sue for like the million or even more. But if you're in New York City, they consider it the same as TLC, which is the taxi and limousine commission. That's only 100,000. So then you're limited to that. So there's all these problems with Uber. And then Frost says, why do insurance companies get to use reverse psychology against the plaintiff by looking at their life history with the law? It's a PI case, not a criminal case. The client didn't cause the accident. Oh, I see what you're saying with the criminal. Well, with criminal stuff, what they're basically trying to say is that if you have a conviction and it's a crime of like moral turpitude, it could come in to evidence. Then they're basically going to argue, well, this is that kind of person, like who's a criminal. So, I mean, yeah, it's kind of like a low blow, but you could kind of diffuse it if you know how to handle that. You could just say like, okay, my client might have had. You just have to front that, as an attorney. If you know it's going to come in anyway, you could make a motion in limine to try to exclude it. But if the judge doesn't exclude it, and depending on what it is, you just have to like front it and just say, look, yeah, it happened. It was like whatever, 20 years ago. They're a different person now. Should they be punished twice? They already served their time or their restitution, whatever it was. That was the sentence for the criminal case 20 years ago. But now they have to be punished again because they are not going to get compensation for their injury case. And, most people will say no. And then you just pick those jurors that will say no. And he also says, why should they question and try to make a plaintiff out to be a bad person when the accident itself affected the client tremendously? Well, because, that's what they want to do, because they want to save their money. They don't want to pay, millions of dollars. They want to pay as little as possible. It's all a business to them. So they're not thinking of it as, trying to make somebody a bad person. They're just thinking about it. Hey, this is a way we could maybe limit our exposure. We could pay less or we could pay nothing. So they just do whatever they can and, pull out all the stops basically. And then Cali Cool says, my accident happened back in December of 23, 1 year of treatment, 2 medial branch blocks, plus an RFA and lost wages, been out of work since January of 24. Yeah, that's pretty serious. I mean, if you've been out of work so long and you've had these, 1 year of treatment, medial branch, that sounds like it could be a serious case. And radio frequency ablation, that's serious too. They're burning the nerves. That could have value. And then Burnt's says, "Hey, Arkady, love your work. Calendar call is October 30th. The insurance company just put a motion in limine. Should I be nervous?" I mean, no. I mean, motion in liminis are always going to be done by both sides. So it just depends on what they're trying to, you have to like actually look at the motion or speak to your lawyer. What's the relief? Because a motion in limine just means that they're asking for some evidence either to be admitted or to be not admitted, right? Excluded. So it's just, that's all it is. It's just kind of like an advanced ruling that in the trial, X is going to be either admitted or X is going to be excluded. Like we just talked about with the criminal, right? If somebody has a criminal conviction 20 years ago, and I feel like, hey, that's not relevant, I can make a motion in limine, exclude that from the trial. Don't allow any questions about that. The judge could say, yeah, I agree, that's excluded. That doesn't matter. Or they could say, you know what, it's a crime of moral turpitude. It happened fairly recently. It is a conviction that under the law, they look at all the law, the precedents of other cases and say under the law, that does come in and that is coming in. So now at least hey, it's coming in. The worst thing is not to know, right? You think, hey, it's going to be excluded. And then all of a sudden, it's coming in and you're not ready for it. So at least this way with motion in limines, So depending on what they're trying to exclude, you just have to find that out. And then, so it could be, but it's not just the insurance company that does them. I mean, your lawyer should probably do them as well for whatever issues your lawyer either wants to get in or keep out. And then Zafraz says, can they use social media pictures with family against you? I mean, with social media, like I was trying to explain, like only if they have something there that would make people think that you're not hurt, right? Like, for example, if you say, hey, I'm so hurt, all I do is I sit at home, I can't get out of bed. And then they have your social media, like racing these BMX dirt bikes, doing wheelies, or I don't know, like jumping out of airplanes, skydiving, I mean, they'll be like, wait a minute, this guy's lying. Look, he's living his best life. He's doing crazy things. He's doing things that healthy people can't do. Then it's bad, whether it's family or friends or whatever. But if, you're honest, if you say, hey, I can go shopping, but I could only carry like one bag, and they have you like on social media carrying one bag, well, that's consistent with what you said, so it's fine. The same thing with surveillance or sub rosa, they call it. The same thing. It's basically like, and you could flip it on them too. You could say, look, that's what you have to do is you have to go to my social media, or you have to go follow me around and, invade my privacy. That's how low you have to go. And you didn't even find anything, right? So just if you're really hurt, just don't have anything out there that's inconsistent with what you said you can't do, basically. And then Paul says, how often do insurance companies perform surveillance on a client? Who would be more susceptible to this? I mean, they usually do it on the bigger cases where, they feel like the surveillance would help them. And what I've seen lately is they kind of do it closer to the trial. The last few that I've seen have been around the time of the trial, at least in New York. Like the one I had where we got 3.5 million. They followed the guy around. I think it was the same month as the trial. They hired some young kid to do the surveillance. It was like completely useless because all they had was the guy coming out of his car, driving his car, coming out of his car, going to the back, pressing a button, the trunk opens, took a piece of paper, then, press the button, the trunk closes. But he didn't say he couldn't drive. He didn't say he couldn't walk or press a button. So it was like the whole thing was kind of like useless. It didn't really do anything. So if they, if they're going to do something like catch you basically doing something that you say you can't do, then sure, then, that's damaging. But if it's just surveillance, and how often, I mean, it depends on them. I think it makes sense if they think that you can hit them for a big number and there's potential exposure, they'll do it because it doesn't really cost them much. Like in my case, they hired some young kid. I think he was like his first job. He never even had any video surveillance experience. And he was driving like his dad's car because you get to depose him too. So we took his deposition, and you also get to get all the outtakes, so get all the raw footage. Because what they do is they surveil you, and then they just pick the best parts of you, like doing things, and then they just show that. But what about everything else? A lot of it might be you walking with a limp, or you not being able to get up out of a chair or whatever, something else. And they don't exchange that. So you got to get all the video, and then you could have your own videographer, show the full story. Yeah, so so I wouldn't really worry about that. Just don't do anything crazy. And then Machine says, do big rig insurances like to wait a year to settle personal injury cases? Um, I don't know. A year? You mean like 1 year? Not really. I mean, they do wait because they want to see like what your injury will be, and also it depends on your lawyer. If your lawyer is like aggressive, if you're all done treating in like 6 months, and the lawyer sends a settlement package. I mean, usually the cases that settle quickly are going to be cases that are smaller, right? Because if you have a serious injury, like you need a fusion or you have a brain injury, you're going to continue to treat, and then the lawyer is going to file a lawsuit, and it's going to take more time, like a year, 2 years, so they could settle, but you want to settle for the maximum. So it just depends on who's handling the case. But I don't think there's any like real across the board, you know pattern with insurance companies. Some settle early, some settle later. But yeah, I mean, definitely, I think if it's like a big rig, like a truck, it would probably take at least a year, maybe longer. And then Dwayne says, do the legal documents in the big accident firms allow for you to fire them, or are you legally blinded to them once you sign? Oh no, you could fire them. It's just basically at any time. I mean, it's if you don't like them, you just get someone else. It's just like, you have a Coke, and then tomorrow you want a Pepsi, so you just get a Pepsi. You're not obligated for anything. You could always do that. Let me see. And then Callie says, I also have a neurosurgeon note that backs up my treatment and suggested I may need surgery as a last resort if pain becomes unbearable. How do insurances look at these types of cases? Well, no, of course, if you need surgery, that will increase the value, because you could say, well, I'm going to have the surgery. I haven't had it yet, but I have the medical necessity for it, right? My doctor says I medically need it, so I'm going to have it. And then, yeah, it increases the value tremendously. Like I had a case with an older gentleman. He was like 80. He got hit by a car. It was like, I think, Geico with 100 policy. And they were trying to offer him like 15,000. And then he went to an orthopedic doctor because his MRI showed a torn meniscus. And the orthopedic doctor says you need surgery. Now he's not going to do the surgery because he's 85, but just I sent a narrative report from the orthopedic surgeon saying, hey, with a reasonable degree of medical certainty, this client needs this knee arthroscopy. And already it went from 15 to, like, I think we settled it for like maybe, I forget, like maybe 80,000 or 82.5, something like that, close to the 100, because he needs surgery. So it increases the value usually if you need surgery. That's helpful. And Larry says, can a personal injury case against New York City take 4 years without my deposition or any offer to settle, or just they are trying to drag my case maybe? I mean, it shouldn't really take that long if you're not even having a deposition. Although New York City, it is kind of slow, but like depending on what's happening, I would call your lawyer and see why is it taking so long? Like what's been happening for 4 years? Because you have to file a lawsuit within a year and 90 days against New York City. It does take some time depending on where you are. Like in Manhattan, it takes sometimes, like now it's taking like 9 months just to get a preliminary conference. But assuming you get a preliminary conference, then in the conference, it'll say depositions to be held by X date. So you just have to hold them. And then that's kind of like the first step of the deposition. So if all this time has passed and you can't even get depositions to go, there must be something else happening, maybe some waiting on another party or some kind of motion practice, or, it sounds kind of like it's not the normal. I mean, the whole case could take like 4 years or even maybe sometimes longer, but but it shouldn't take 4 years to get to a deposition. And then Harold says, I really enjoy watching your videos. They are very educational and insightful. Oh, thank you so much. I really appreciate that. And Trevor says, is the name's a lawyer, a good lawyer? I don't know who they are. So the best thing, if you wanted, me to do a review of a lawyer, it's probably better to text me and then tell me a little bit about your case, just the facts, the injuries, your city, your name, and then what I could do is I could run a search, and then I could maybe email you the results. But I don't know who that lawyer is. But I also probably can't talk about other lawyers like on a show like this because it's public. But yeah, I'm happy to do a consult for you if you need a private consult. It's confidential and it's also free. And then Harold also says, we have filed the summons and complaint and received the answer from the defendant in a medical malpractice case. What is the next step? Okay, so if you filed the lawsuit, you got the answer. The next step is usually to do, if depending on where you are, like if you're in New York, you have to respond because with the answer, they'll also ask you for discovery. You respond to their discovery. They'll ask you for a demand for bill of particulars. So you respond to the demand for bill of particulars, which is like your name, what did they do wrong, the negligence, what are your injuries, your damages. You list everything like from the medical records. Usually the lawyers prepare that. And then you move for a preliminary conference. It's called a request for judicial intervention. So you have a judge intervene. Basically, you pay like $95, and then you wait, and then you get a preliminary conference. And then you show up to the court conference, and then you get an order saying deposition of plaintiff will be on X date, deposition of defendant will be on Y date, plaintiff to serve responses to defendants' requests for documents, and defendant, of course, to serve responses to plaintiff's requests for documents. So basically, you're exchanging documents and you're setting deposition dates. And then you have to actually do all that stuff that's in the order, right? Because that's just a scheduling order. You have to actually get all that done. And then, yeah, that's about it. And then you just then you're in discovery. Once discovery is finished, then you put it on the trial calendar. So kind of like what you're describing is just the very, very beginning, right? Because you filed a lawsuit, they answered the lawsuit. So now you have what's known as issue has been joined, right? Because whoever you sued has now appeared. They're in the case, which is good. So now you just start the case basically. And Jeff says, how long does a case last after depositions and surgery was recommended? After depositions and surgery? Because they're two different things. Like depositions are basically like just like I just described, right? When they ask you questions about liability, like what happened, and what your injuries are. And surgery is obviously, there's many different types of surgeries. So there's not really a set time that it would last. It just depends on the case, right? Depends on like what stage the case is in now. If you had depositions, you still need to do maybe IMEs, put it on the trial calendar, wait for the trial. So depending on where you are, right? Like in the Bronx, you could be ready for trial, put it on the trial calendar and wait like 4 years to get a trial date. Other places, maybe like Florida, I'm hearing it's quicker. Like people, file for a trial and they get it in like 6 months. So I couldn't really answer that. It just depends on like where you are and what specific. But I would ask that to your attorney if somebody's handling it for you. But the fact that surgery was recommended, it also depends on whether you're going to do the surgery. Because if you're going to do it, then they're going to do another deposition after the surgery. But then the case value will go up tremendously. If you just have a medical need for surgery, like a recommendation, but you're not going to do it, they might not get a deposition, but you probably still want to supplement the pleadings. Like in New York, you would supplement the bill of particulars and say, hey, but there's a medical need for surgery. So then you could argue that. And then at trial, you would say, well, I haven't had the surgery yet, but I will have it maybe in the next year or two or whatever. So that's usually how that plays out. And then Jay says, I was a passenger in a flex bus accident on the freeway, rear-ended a utility truck, 4 bulging discs, 4 millimeter tear, 4 injections, happened in February, done with therapy. Okay. Yeah, it sounds like a good case if you had, injections, you got done with therapy. So it should probably settle, or, you could file the lawsuit depending on like where you are and who's handling it. And then a car says 31 years old, venue in Las Vegas. Okay. Which one was a car? I forget now because I had so many of them. That's the one with the sprain. Okay. Yeah, I'm not too familiar with Vegas. I think Vegas is okay, depending on who you have, if you have a real trial attorney. The best thing to do, if just text me 347-566-9595. We could do a quick call. We can get all the information. I could give you some good insights. And then Baby Boy says, hey, buddy, you rule. How much is a lumbar fusion, a cervical fusion, and a hip replacement revision worth in New Jersey, Atlantic County? Well, yeah, I mean, look, it's a lot because like a lumbar fusion, a cervical fusion, and a hip replacement. Wow, that could be into the millions. I'm not too familiar with like Atlantic County specifically in New Jersey. I know New Jersey's maybe a little bit more conservative compared to New York, but it's pretty good, pretty comparable. So in New York, I would think like somewhere like in Brooklyn or the Bronx, could be worth like easily 3-4 million. So maybe in New Jersey it's a little less, but still should be like 2 or 1.7. Just off the top of my head, but I wouldn't, again, I wouldn't know exactly. And he's saying, should I take another loan like 15K? I'm broke and my case is taking long. It's a 3 million policy, already had the hip replacement and next fusion, already owe 65K. I mean, I don't recommend it because yeah, then you end up owing a lot. And then when you settle the case, instead of you getting the money, you have to give the money to this funding company. But if you have to, just make sure it gets somehow capped, So if you take whatever amount, like 15, you pay back maybe like, 20 or 30, but not like you don't want to take 15 and then have to pay back 100, right? That's kind of crazy. And then Callie Cool says, I'm in Philadelphia. I was struck by a tow truck, but they said they only have 15,000. So my lawyer's trying to get them to pay the difference. But my previous lawyer didn't add my driver in the lawsuit. That's weird. That might be a mistake by the previous lawyer. Yeah, you definitely want to sue everybody. But if it's a tow truck, how could they only have 15,000? Usually tow trucks should have, substantial coverage, like 1 million. And then Carrie says, I had a tripping fall on an uneven sidewalk with a tree that lifted the sidewalk, fractured my kneecap. In discovery phase, I did the interrogatories and questions. Okay, that's good. Yeah, so probably next step will be depositions. It sounds like a good case if it's like a defective condition, an unsafe condition. Yeah, it sounds like a pretty good case. And Callie says he's trying to pull the driver back in. Yeah, if you're within the statute, you can just amend to sue them. You can do that. Okay. Oh, and Carrie says, I finished the interrogatories. We're in the discovery phase. How long does it take, if any, to do depositions, and how much do you think this claim is worth? I fell in California, Los Angeles. Yeah, I mean, from what I've heard, Los Angeles is a pretty good venue. I mean, depending on who you have handling it, if you have a good lawyer who's a trial lawyer, yeah, it shouldn't take too long. I mean, if just depositions, probably a few months, and then put it on the calendar. I don't know the time frames in California. I do see some cases that I watched, like on the Courtroom View Network. They're old. They're like 7 years old. But yeah, maybe that was just that case for whatever reason. It doesn't mean every case takes so long. Probably like a few years, but and then you said an uneven sidewalk, fractured knee. Fractured kneecap is pretty serious, so it should be a good case. It should be a pretty big result, as long as you can prove liability, you have an expert, and you have a good trial lawyer. It should be fine. I wouldn't know exactly what it's worth, but like in New York, probably something like that with a fractured kneecap. It could be like 500,000. It could be even like 850, 1 million, depending on, what it is. Like I know the tibial plateau fractures in the knee, those sometimes could be worth even more because that's a pretty bad injury. I've even seen over 1 million on those. And then KCV Star Biker says, is it normal for the defense to ignore the time limit demand expiration if their insured driver hasn't had a deposition yet? I don't think so. I don't think that's normal. I've never really heard of that before. I mean, if they're ignoring it, then you just have to, it'll be higher, right? Because if they ignore the demand, then it'll be whatever number is in the demand, that'll be higher. And then he also says, and then what do you do after the defendant is deposed? Send another time limited demand for more than the first one due to the delay? Yeah, you could do that. Exactly. You could just say, well, you had your chance for, whatever. You had your chance to settle for 100,000. That's all your policy is, but now it's 500,000. It just depends on how you want to structure it and what you want to do. But yeah, you could do that. You could stair step on up and just keep the pressure on them. Yeah. So, okay. I have to step out just for a second. Sorry about that. I'll be back in like 2 minutes and then we could continue, finish up. I think we have a few more questions. Oh, we've been at it for almost 50 minutes. So, yeah, I just have somebody at the door. So, let me step out for like 2 minutes and then we'll finish up. Okay. Sorry about that. Be right back. Oh, okay. Sorry about that. We're back. Let's see. So what question were we up to? We were up to, I think, um, we did this one, right? The star biker question about what do you do after the defendant is deposed? So yeah, after the defendant is deposed, you send another time limited. I mean, you could send another demand. You don't have to because you've already sent a demand. You could just stick to the original demand and say, look, because the original demand should say like, let's say it's 100,000 or whatever the number is before X date, and then after the 30 days, it'll be 500,000. So they know what it is. So if they want to pay, they'll just pay. If they don't want to pay, then you just prepare it for trial. The key thing is not just to send the letter, but also to while the letter is pending, right? So you give them like 30 days, let's say, or whatever, you can give them 60 days. But while the letter is pending, you want to show them, hey, exchange your expert, or take a deposition of a witness, like a non-party witness, to show them like I'm not just bluffing. If you don't pay what's in the letter, I'm taking actual steps, like I'm deposing a witness that's going to prove my liability. I'm exchanging this expert, like a neurologist, to show you, hey, this is a real brain injury case. Whatever it is, I'm hiring a life care planner or an economist to get my wages. So then they see, wait a minute, this guy's not just like blowing hot air. He's the real deal. And then basically you have to coordinate all that. So like while the letter is pending, you're taking actual steps. So then you don't really care. You're like, okay, pay me, or if you don't pay me, I'll get it from the jury. And then they get scared and then they pay. So you have to do it that way. And then Machiavellis says, if I discovered a private investigator behind me and I took pictures and videos of him and he saw me taking pictures, can that affect my case? No, I don't think so. I mean, like, again, like the only thing that really could affect the case is if the private investigator, has recordings of you doing what you can't do, like what you said you can't do, like has you doing like cartwheels or flips or whatever, something that you cannot do, that would affect your case. Like the fact that he's just there and you take pictures of him. I mean, you could take pictures of him because you don't know who he is. Maybe he's like a crazy person, right? You want to report him to the police. You don't know that he's from your case. So yeah, I don't think that matters. Okay, and then Sandy says, my attorneys received the declaration page from the other party stating the limits were 500,000 about a year and a half ago. We discovered it's only 300. Can they go after the 500? So it was 500, but now it's 300. I don't know. It depends on like the specific circumstances of how that happened and who made the mistake. If it's like just a mistake and it really is 300, then you might be limited to the 300. I'm not really, too sure how to answer that, because how could it be that they said it's 500, but then it's really 300? Somebody either made a mistake, maybe your attorney made the mistake, then, you can't do anything about that. But if the other side really provided the wrong deck sheet, or if it's, it just depends on what actually happened. You have to do a little bit more of an investigation. And then Dwayne says, is there any way to find out the limits of the insurance policy without a lawyer? I mean, sometimes you can, depending on the state. You can call the insurance company and ask them. I don't think they're going to tell you usually. In New York, they do have to tell you, but usually with a lawyer, you send them a letter. I think it's like 4520F, and you put, hey, you have to tell me the limits, and they usually tell you. But in other states like New Jersey, they don't have to tell you. So they might say, hey, it's, we don't have to tell you. But once you file the lawsuit, you're going to find out anyway. So it's usually not a big issue. And Frost says, did you have a client get mad at your firm before, maybe because the settlement offer? Also, did you ever have to deal with a rude client and have to discontinue their case? So you're saying get mad at us because of the settlement offer? You mean the settlement offer was so low that the client got upset with the offer? I mean, not really, because we usually just tell them like this is just the first offer, or it's not really a real offer. It's just them trying to, start the discussion or whatever the issue is. And did we ever have to discontinue because of a rude client? I don't know. Maybe like once or twice. Not often. Maybe like once or twice. Sometimes, some people are just like crazy or whatever, and you have to like. It's not because you just have to. You have irreconcilable differences, or some people are just like not really a fit, right? So you might want to refer them somewhere else, or just not able to help them. But not that I could think of off the top of my head, though. And then Adrian says, what venue in New York grants you the most settlement money pertaining to the 5 boroughs? I mean, usually I would say the Bronx is good. I mean, Brooklyn is not bad either, although Brooklyn's becoming a little bit more like gentrified now. It's a little bit more like conservative. I mean, it really depends on the case. So you could do well anywhere, but usually, I think just what people are saying generally from, doing cases, probably the Bronx is definitely one of the best, and then Brooklyn probably the second. Queens is kind of like a mixed bag because, like I was saying before, it's just so many different groups in Queens. And then, what else is there? Staten Island tends to be conservative. Manhattan also tends to be conservative, although you could do well in Manhattan. And then I think, those are pretty much all the boroughs. The 5 boroughs. Okay. And then Dwayne says, I ignored my lawyer's call today from the bigger firm waiting for your recommendations on a new lawyer. Should I continue to just ignore them until I have a new lawyer? I mean, you could speak them if you want. Like, I think the case, from what I remember, is brand new, right? So it's not really too much of an issue. So no, I mean, it shouldn't take too long. We should probably be able to find someone good for you. And whether you speak to them or not, I think that was the issue where, yeah, I remember. I mean, it's probably better to speak about that privately, but yeah, it's up to you. I think you could ignore them for a few days. I don't think anything's going to really make a difference. And then Sandy says, it seems like a mistake on the insurance part, saying they had 500 when it was 3, and I'm hearing they should be able to go after the 5 regardless. Policy was changed 3 weeks before the accident, but insurance said 500. Yeah, I mean, I don't know. Ask your lawyer. I'm not really too familiar with, like, I don't really do insurance law, so but yeah, I mean, but it's more like contractual. But if they told you it was 5 and they sent you the documents it was 5, I would think, yeah, maybe you can try to go for 5. And then Billy says, if my lawyer is doing a focus group, what's the benefit? I have 2 herniated discs and a hand tear with months of therapy and 2 injections. Why is this necessary? Seems worth over $100K policy. So yeah, a focus group, what they're basically trying to do is see what the attitudes will be of that focus group. So usually they get people kind of like you would do in a trial, but you don't want to, like, test your case in the actual trial, right? Because then what if people say, hey, what about this issue? And then you haven't thought of that issue. So what a focus group does is you have, let's say, 20 people and you pay them, $100 each or whatever, maybe more, $200 each. And you basically get an hour of their time, whether it's on Zoom or in person, and you present the case in a neutral way. You say, hey, here's the plaintiff version, here's the defense version, and then you see what feedback they give you. And then if they give you nice feedback, then you say, wait a minute, okay, I didn't think of this. Now I can take this issue and I could, I could, if it's a problem, I could think of how to diffuse it, right, or how to deal with it. If it's something good, I could maybe spend more time on this because they think that, depending on what the issue is. So it's not a bad thing. I mean, usually, you don't do it for cases of only 100K policy. Usually you do it on bigger cases, but if the lawyer wants to do it, it's not a bad thing. And then FBF says, how come a city truck wreck tends to settle most cases for good amounts while city being at fault, lawsuit involving punitive damages? So a city truck. Well, the good thing about city trucks is that they don't have a cap, right? You can go for, like, usually with the city, you can go for a big amount, even millions of millions. So they have a lot of insurance. Tends to settle. I don't know. Like in New York, they don't really settle, or if they do settle, they offer low amounts. So usually to get real money from the city, at least here in New York, you have to kind of like get to the jury, to the trial stage. But yeah. But yeah, I mean, city cases are good because of that issue, right? There's no cap, so you can get a big amount. And then Jorge says, hey, Mr. Arkady, my attorney filed a proposal for settlement 20 days ago here in Florida. I have a mediation next month with a projected trial date for January of 26, 450 in medical bills, 1 million policy. No, so that's good. So yeah, you can possibly settle, and if you don't settle, then you go to trial and you can get a big result. Maybe you can get the full million. If you have 450 just in bills, I would think the injuries are probably worth $1 million or more. And then Frost says, what if someone hires you from, let's say, Alabama, and you find a partner, and let's say the case goes all the way to trial? Would you fly out and do the trial? Yeah, I mean, I could if they wanted me to, if the client wanted me to, and the lawyer from Alabama wanted me to help, I could do that. I mean, absolutely. I just have to make a motion to get admitted pro hac vice, right, into that state. And then I could maybe do the trial together with the local lawyer. And then Myrna says, hello, I had a slip and fall, 3 surgeries in my apartment building. I heard from a neighbor that it seems that the city's taking over the building because of too much violations. Would that affect the case? No, because it already happened, right? So it's whoever had the insurance when you fell back, a year or whenever you fell back at that time. It doesn't matter what happens now, whether it's the city or they could sell the building, they could do anything now. It doesn't matter. But it sounds like a good case. Slip and fall, 3 surgeries. So yeah, if you need a consultation, just text me, 347-566-9595. And then Tony says, hi, super lawyer, an employment sued. Who paid the settlement, the insurance or the owner? Well, if they have insurance, usually the insurance. If they don't have insurance, then I guess it has to be the owner. Although I don't really, handle too many employment cases, so I'm not too familiar, but probably it would be the company if they don't have any insurance. And then Chris says, what happens if the business that hit you said they had 1 million when it was 500, but if it's 500, the lawyer said they can go after the business assets possibly since they wanted the full policy? Well, I mean, yeah, if they only have 500 and then you get a bigger verdict, then you go after the company if they have assets. Or what you could do is you could say, hey, pay me the 500, you have 30 days. And if they don't, then you could tell them right in the letter, well, then I'm going to go for 1 million. And then the insurance company could be liable, right, for anything above the 500 because they didn't negotiate in good faith, which is like an open policy. But that has to be in a state where you have bad faith law. So that's possible too. And then White Trash says, I didn't give much care about law until I got T-boned. Now I'm studying your videos to work with my legal team. Just aced our depot. Oh, that's good. Yeah, that's what it's all about. Awesome. I'm glad that it was helpful. Yeah, that's good. Congratulations. That's good that you did a good job on the deposition. And then here's a question. How do I use all the bad and shady things the doctor did to get defense scared of jury mad money leverage? The doctor even lied at his deposition. So you want to use the bad things the doctor did. I mean, you could just have your lawyer bring it up, or you could put it in a settlement letter. These are the bad things. I don't know which doctor you mean. You mean the IME doctor, the DME? You could say these are the bad things. What I do is I send a like an IME watchdog, independent person with the client to the IME, right? So then they record everything that happened. So if the doctor says, "Oh, I spent an hour," but then wait a minute, the watchdog's like, "No, it started at 7:10 and it ended at 7:20. You only spent 10 minutes, So that's good to have too." And then Myrna says, okay, thank you. I will reach out if anything. Oh, yeah, absolutely. No, you're very welcome. And then Billy says, my lawyer said he's going to combine my lawsuit with my new accident. It's the same insurance, almost the same injuries, exacerbating PTSD and back. Could they be combined in a settlement? Second case, not in suit yet. Well, no, it's probably going to be two separate cases or two separate, because it's two separate insurance companies, two separate settlements. But you can combine, sometimes you can combine the cases or the injuries together. So depending on the law in your state as to jury instructions. And then Chris says, thank you. It's in Nevada. And if you get the full 500 because of the injuries, could you go after assets? Yeah, you could. You could go after the assets if you get more than the policy. And then Billy says it's the same insurance. Oh, if it's the same insurance, yeah, possibly you could. I'm not too familiar with that, but I think you could sue if you have two different accidents. You have to combine them, and then the jury would have to decide, which accident caused which injury. If it's two separate, say, car crashes that happened months apart. Yeah. Okay, I hope this was helpful. I guess I'll go because it's already we're over an hour. But yeah, we'll do a few more of these. We'll try to do one next week, and then I'll do a few I have a few videos that I'll do as well. I'll do a few new shoots. Let me know if you want any video topics in the future. Maybe some verdict searches. I know the common questions are how much am I going to get, all right, and how long is it going to take? So I'll try to do something about that. And absolutely. Okay. If you have a case, I wish you the best of luck in your case and get full justice, complete and full justice. And if you have any kind of injury, I wish you the best of health and get a full recovery. Okay, everyone, have a great day and talk to you very soon. Please like and subscribe to our channel. We are here for you. Our goal is helping serious injury victims and families. All the best, everyone.